Hello and welcome to Mortgage Solutions. I'm your host Mark Rigney, and today we are going to discuss the effects that a divorce can have on a mortgage loan. Now unfortunately, at least 1 out of every 2 marriages end in divorce, and oftentimes there is a mortgage involved. On today's show, we're going to speak with a prominent divorce attorney, Mark Astor, and he will advise us on the steps one should take when going through a divorce. Now, there are many pitfalls in determining how the mortgage will be handled through the divorce process, and by paying attention to today's show, you could save yourself a lot of time and money if you know what to expect and how to handle each situation. Hi, Mark, and welcome to the show.
Mark, how are you?
Mark, if a married couple has decided to divorce, what is their first step as it pertains to the mortgage?
Well, the most basic thing is to make sure that the mortgage is paid. And it sounds simple, but in most families, one party is responsible for the finances while the other is responsible for other things. So both parties need to understand who is going to be paying the mortgage and to make sure the mortgage is continued and paid continuously without default.
How do the parties involved determine the value during the divorce process?
Well, there are many ways. Certainly the simplest way is for the parties to agree on the value of the home. If the parties can't agree on the value of the home, they can use outside resources such as the tax assessment or online providers that can help with the assessment in a non-professional manner. The last manner in which one can establish the value is to hire an appraiser.
Right.
And the appraiser will then give the parties the value of the property, the fair market value of the property.
Now, this is very common in our community today. What should the parties do if they owe more on the house than the house is worth?
Well, the process would start with determining if one of the other parties wants the house at the end of the case, end of the divorce, and whether the house is going to be sold.
Okay.
If the house is going to be sold, then there are avenues available with the bank that you may be able to negotiate a short sale, which the bank would accept the sales price and not hold the parties responsible dollar for dollar for the deficiency. Other possibilities are unfortunately going into bankruptcy to protect possible foreclosure. And then the other issue that could be utilized is one party taking the property and accepting the loss. I
see. Now, that being said, if the house is underwater, should one party decided they want to hang on to the house, should one of the parties accept compensation if it's underwater? Should they expect some type of payment?
Well, that's one of the biggest problems that we have as trial lawyers in this area, because the judges are doing all different types of things with this situation.
Not much consistency?
There's not a lot of consistency because the law gives the judge the discretion to do whatever he or she would like to do, and in some cases they award the house to one party with no compensation, negative or otherwise.
Now, we hear a lot about quitclaim deeds. Does a quitclaim deed take the name off the mortgage and alleviate the vacating spouse from the responsibility of the mortgage?
No. The deed or the title to the property is completely separate from the obligation on the mortgage, and the loan companies understand that they have a signer on the deed, a deed of trust, and that person or those persons are responsible irrespective of who holds title. So a quitclaim deed would be providing that one party gives whatever interest they have to the other party, and it absolutely has no effect on the mortgage itself, and not between the mortgage lender and the owner.
The lender won't recognize that. They won't accept it. It has no bearing on their feelings of it at all.
They would just accept it as a transfer of title, and in some cases, in fact, there has to be care taken because some mortgages have what's called due on sale clauses, and some mortgage companies interpret a quitclaim deed as a sale of the property.
Really? How can the vacating spouse get their name removed from the mortgage or the deed?
Well, getting their name removed from the deed is simple. If the parties agree, it would just be doing a quitclaim deed, and therefore the property would be in the owner's name alone. Removing a party's name from the mortgage is more difficult. In some cases, and in very, very rare situations, you can negotiate with the mortgage lender to allow that party to be released from the loan.
Okay.
That typically doesn't happen because the mortgage lenders would like to keep as many people responsible on the loan as possible. So that's one rare possibility. The most common possibility is to obtain a refinancing, where the party that keeps the property obtains a loan and removes the other party's name from the mortgage.
Let's say they go to court and the judge awards the house to one spouse or the other. Does that release the obligation of the vacating spouse?
No, not from the mortgage.
Not from the mortgage.
The mortgage is a contract between the party who owns the house and the lending company that lent the money to purchase the house. And although the court has different powers to enforce such an order, it has no bearing as between the owner of the property and the mortgage.
You mentioned refinancing the home. Is that selling or refinancing the only way to release the obligation from the vacating spouse?
Well, there could be foreclosure. I mean, in bankruptcy, those are the only other two ways that they could be released, as far as I know.
But just that, or selling or refinancing the house, is their only options?
As far as I know.
Or short sale, or take some other effect. Okay. Will the vacating spouse have to pay the other spouse back for the down payment they invested when they originally bought the home?
Well, there is a provision in our law that allows for tracing of down payments that are made from funds that were not acquired during the marriage.
Okay.
So if you purchase a house in the beginning of your marriage and you invest $100,000 for money that you had prior to the marriage, then there is a tracing method where you can be compensated for that.
But it's your responsibility to prove that those funds were yours before you entered into the marriage. Is that correct?
Yes, sir.
What happens if the property settlement agreement or court order requires a spouse to refinance the house, but they don't have the ability to do so? They don't qualify, their credit score is not good enough, their assets, debt ratio, things of that nature. What happens if the spouse who keeps the house is unable to refinance it?
Well, at that point, if it's court-driven, meaning if there's an agreement that's incorporated into a final decree or there's a court order requiring it, the first inquiry by the court is whether the person who is not refinancing is doing it intentionally. In other words, is just doing it to spite the other party, or is not making its best efforts to do the refinancing. If that's the case, then the court can use its contempt powers and levy sanctions, which include jail time until the person complies with the order.
Wow.
If the person truly cannot refinance because of financial position, the current market, the underwriting problems that people are having now,
which is common today,
then the court will have to fashion a different remedy. And the remedy would be ultimately to sell the property and more likely than not, hold the party who has to sell the property responsible for any loss.
So that the spouse that retains the property might be forced into selling it?
Yes, sir.
What happens if a judge orders one spouse to remove the other spouse's name from the title or whatever, but they fail to do so?
Well, that's, like I said, if they fail to do it and it's an intentional act, then the court can use its contempt powers, and that usually works.
Okay.
Because people don't typically like to spend the weekend or day in jail.
Yeah.
But more
motivating factor there.
more times than not, they'll fashion a remedy that will, if the person in the first place agreed to do it, then they're going to be the one who's responsible for the end result.
Is the vacating spouse liable for half of the mortgage payments if their name is not on the mortgage but is on the title?
Well, the inquiry is two parts. One, as between the mortgage company and the party who's vacating. No, they have no obligation to make payments.
Okay.
If the case is in the crux of the divorce, then the party who is vacating may be held responsible for making mortgage payments because the name is on the title, and that would be done by a court. Or in the alternative, the court could give credit to the spouse who makes the mortgage payments for principal reduced during the time that the parties are separated.
Okay. Okay. If one party makes a payment on behalf of both parties, can that payment be used in a court of law as child support or some other alimony or something to that effect?
Only if there's a specific agreement that the payment would apply to child support and or spousal support, or if the agreement is incorporated into the court order.
So is that would have to be in the separation agreement, is that correct?
That's correct.
The parties just couldn't agree on it as they go along, it would have to be already written in verbatim, is that correct?
That's correct.
What if a spouse, here's a good one, and this happens a lot. What if a spouse defaults on the mortgage during the divorce process?
That's a good question, and unfortunately it's a more common question now than it has been in the past.
Right.
The issue is whether the court has authority to require the parties to make a mortgage payment.
Okay.
And in my experience, if the property has equity in it, then the courts will require in some fashion for the parties to pay the mortgage, although it's not a given.
Okay.
Some of the courts, some of the judges believe that it's up to the parties to decide, and if one of them doesn't want to make the mortgage payment, then that's going to affect them negatively. If there is no equity in the property, then the court really doesn't have the authority to order a party to pay for the mortgage, because they only have the authority to maintain assets, and by definition, a property that's upside down is not an asset; it's a liability.
Okay. Okay. Is post-divorce property at risk if one party defaults on the mortgage during the divorce?
Well, post-divorce property, assuming the property's been divided, could be impacted if one stays on the mortgage of a marital piece of property, the other spouse takes it, then defaults. That party is still on the mortgage, so the mortgage company is going to look to the other party to satisfy the deficiency. They can then get a deficiency judgment and then attach property after proper suit that would not be involved in the divorce proceedings.
Okay. What effect will the title have on the division of equity if one party is not on the note?
Well, the division of property is going to be based on when the property was acquired, not on the title in Virginia.
Okay.
So irrespective of what the title holds as far as the owners are concerned, the equity, the marital equity, is determined based on what was acquired during the marriage.
Okay.
So the parties are each entitled to their equitable share. Virginia is not a 50-50 state. Virginia's equitable distribution. So as long as the asset was acquired during the marriage, then the parties have the right to seek a portion of the equity.
Okay. Okay. If the home was purchased during the marriage but put in only one party's name, can the other spouse expect to be compensated if there is equity in the home?
Well, the easiest answer to that question is yes, assuming that the house was purchased during the marriage and put in one spouse's name or the other for no reason other than that. We get into some complicated issues if the house was put into one person's name because of contributions that came from that spouse that were not marital funds. So it all depends on how the house was purchased and the reasons why the house was put in the person's name.
If they built a house, if they were married and they built a house together, will the person be compensated for equity that they helped build if it's during a construction process?
Well, if it's purchased during the marriage and it's built during the marriage, then both parties have the equitable rights to the equity.
Okay. Okay. What if they can't sell and neither of them qualifies to refinance? What remedies does the court offer in a situation like that?
Well, sometimes what I've seen, unfortunately, is the court to do nothing.
Is that right?
They just leave the house in both parties' names and they let the parties fare with it as they see fit. One of the important distinctions that occurs that upon divorce, if the parties hold the property, as they usually do when married, as joint tenants with right of survivorship, or joint tenants by the entireties, once the divorce is entered, they're just tenants in common.
Okay.
Which means that they become partners in the property rather than married couple in the property. And that has other legal distinctions as far as how the property is going to be eventually dealt with after the divorce. You have to file a separate suit called a partition suit.
Okay. If during the process they are able to refinance or sell the house and the vacating spouse receives compensation for that, is that income that the vacating spouse receives, is that taxable? Do you know?
Well, it's not taxable as a property distribution. There would be certain considerations